My name is Martin Rosenfeld. I am a family and divorce mediator. I am an attorney as well. I have a practice in Fair Lawn, New Jersey. And I'd like to talk with you just a bit about what I do as a mediator in terms of a divorce agreement. In the state of New Jersey, the agreement is referred to as a property settlement agreement. Other states have different terms, but for the purposes of our discussion, we will simply talk about a divorce agreement. As a mediator, my work is not defined as the ability to convince people to do or not to do certain things. My work as a mediator is simply to facilitate, to allow communication to take place between the parties in the hopes that we can reach a resolution. I have found that in mediation, people are confident that they are able on their own, after all, they're two consenting adults, they're able on their own to reach an agreement on various matters that otherwise would have needed to have some adjudication by a court of law. A divorce agreement is something that has many possibilities. I will say that no two divorce agreements are the same, but in a mediation process, we often try to deal with some of these issues. I'll just briefly outline them in the few minutes that we have to spend together. There are financial aspects to an agreement. The financial aspects could deal with property, bank accounts, obligations. Financial obligations, of course, would relate to such matters as the possibility of alimony and the possibility of child support. While the financial discussion may take up a great portion of time for some people, the fact is that in all states, the most important aspect of the agreement is that which has implication for children. If there are children of the marriage, there has to be a discussion in a proper agreement about visitation, about medical coverage for children, about what will happen with regard to expenses that are not reimbursable by medical coverage. There needs to be a discussion about the time, quality time that is spent with the children vis-a-vis their parents, and many other issues that may come up. Issues about grandparents, issues about how decisions will be made with regard to the children, etc., etc. The matter of custody is something that needs to be discussed as well. In many states, there is physical custody, which refers to a home that is maintained for the sake of a child or children by one parent. And then there is the question of the legal custody, decisions that need to be made by both parents. Other decisions would involve the question of tax implications, for example. When a parent provides support for a child under certain predetermined conditions, they are permitted to use the term of dependent child for the sake of lowering their taxes. That needs to be discussed as well. One of the more important issues of all agreements, in my opinion, would be issues that may develop in the future. Parties can have the most wonderful agreement, but if they can't agree on the agreement's meaning later on in time, I try to have a discussion with them about what they will do at that point. What they will hopefully not do is go back to court. It is costly, it is traumatic, it is not something that does any good for anybody in this particular process. In particular, does no good for the children. So we do talk about future disputes, and of course I try to get the parties to understand that when you can mediate, you certainly are much better off doing so. You do not want to go into court. So mediate, don't litigate is truly the motto of not only my mediation practice, but I would say of the mediation practice in general. Mediation will help you communicate better in the future as problems arise, even after your divorce. And please remember, those of you divorcing with children, that while you will give up your relationship as husband and wife through the process of divorce, you will always be co-parents, and therefore you should make all your decisions accordingly. Thank you.